In 1861, Taylor and Lewis made a contract to hire the Surrey Gardens and Music Hall from Caldwell and Bishop on 4 separate summer days a few weeks apart. They planned to present entertainments, including a military and quadrille band with 35 to 40 members, al fresco entertainments, minstrels, fireworks, and full illuminations, a ballet or divertissement, if permitted, a wizard and Grecian statues, tightrope performances, rifle galleries, air gun shooting, Chinese and Parisian games, boats on the lake, and, weather permitting, aquatic sports. In 1861, these would have been remarkable grand carnivals. Unfortunately, 10 days before the first carnival, there was an accidental fire, and the music hall burned to the ground. By that time, Taylor and Lewis had spent a lot of money getting things organised, and so they sued Caldwell and Bishop for not providing them with the music hall. What should the law make of this situation? On the one hand, Taylor and Lewis really had spent a lot of money preparing for a carnival they now couldn't host. On the other hand, Caldwell and Bishop could hardly build a new music hall in 10 days. Justice Blackburn gave a wide-ranging and creative judgment, reaching as far back as the Code of Justinian in Roman law. He found, as his analogy, earlier cases which had decided that if a contract relied on the particular skill of an individual person, such as a painter, and that person died, further performance would be excused. So the painter's executors wouldn't have to finish the painting. From this, he identified the notion that each contract included an implied term that if the very subject matter of the contract was destroyed, such that the contract could no longer be performed, well then further performance was excused. He said, "The principle seems to us to be that in contracts in which the performance depends on the continued existence of a given person or thing, a condition is implied that the impossibility of performance arising from the perishing of the person or thing shall excuse the performance." In modern contract law, we call this the doctrine of frustration, and it is regarded as a rule of contract law rather than as an implied term between the parties. But it is still the case that if the very substance of the contract ceases to exist, the contract is frustrated and further performance is excused.